Hey, Legal Rebels, this is Tom Martin. I'm the founder of LawDroid, and this is my podcast, LawDroid Manifesto, where I interview legal innovators about how they do what they do. In this episode, I interview Judge Scott Schlegel of the Louisiana Fifth Circuit Court of Appeal, who's brought technology to the justice system and believes it's his life calling to help people by making justice accessible. Welcome to the LawDroid Manifesto podcast. I'm very excited to have my guest for today, which is Judge Scott Schlegel. If it's possible that you're not familiar with him, Judge Schlegel is a leading tech pioneer in the courts. He has really opened people's minds as to how to use technology to give people greater access to the courts. Recently, he's been elevated to the Fifth Circuit in Louisiana, and he's gotten all kinds of awards. We've got the Rehnquist Award. He's been inducted into the Louisiana Justice Hall of Fame. And he also serves as chair of the Technology Commission in Louisiana. So with that, I'd like to introduce you, Scott, and if you could tell us a little bit more about what you're doing.
Yeah, well, thanks for having me, Tom. I appreciate it. I always appreciate the opportunity to talk to audiences around the country about the need to modernize our justice system. As you and I have talked many, many times, there are so many things that we can do a little bit better just to make the courts more accessible, more efficient, and more effective. So as you just noted, I was elected to the Fifth Circuit Court of Appeal late last year. That's the Louisiana Fifth Circuit. A lot of people try and give me a promotion of the U.S. Fifth Circuit. So if you know somebody, I'll take it. But I'm on the Louisiana Fifth Circuit. I served a decade on the trial court, the 24th Judicial District Court in Jefferson Parish, where you and I met during the pandemic to try and do things a little bit different to make sure that the courthouse stayed open during those tough times.
Yeah, and I know that, the pandemic was a bit of a, it was a bit of a shot in the arm for getting technology into courts, into the practice of law, all of that. And I know that you use some of it to keep the court doors open during that time. How was your perception of it? Did it change things? Did it open people's minds?
Yeah, it absolutely changed things. I mean, as we've discussed on many occasions, I'd been using simple technologies for many years prior to the pandemic. So because of that, thankfully, we were able to scale at the right time. Certainly, we're using Zoom before Zoom was a word, and that was a big challenge. Just even that scaling that, because when you think about it, the technology that we're using right now, Zoom is phenomenal, but when you're sending everybody home and nobody can come to the office, there's no real IT. And that's always been a really struggle with courts in general. And it's still a struggle for courts that there are we don't have technologists. We don't have IT on from the corporate America perspective, we don't have IT. If you're lucky, you have one or two folks that keep the servers running, hand you a laptop and say, let me know if you have any issues. You've got you've got email and Microsoft Word on there. You're good to go. But when you shut the courthouse down and you send people home, look, what's your bandwidth? What devices do you have? We weren't familiar with it. And thankfully, we've become familiar enough with Zoom or any video conferencing platforms that we're able to kind of keep that as part of our day-to-day activities. I wish it was a little bit more sometimes. A lot of what we do can, the hey, how you doings can be handled by Zoom. But I'm also not a proponent of tearing the courthouse down. I was a trial lawyer, I was a prosecutor, I was a trial court judge, and there's something about being in the courtroom and being able to present evidence and interact with the jury and interact with the witnesses that you cannot replace with Zoom and with any technology. So again, not a fan of tearing the courthouse down, but a big fan of, when appropriate, use the available technologies, and you don't have to get super fancy. And I know we're going to talk about AI, but that's the bright, shiny new object. Can we just optimize what we have? Can we just, can we just learn how to use Zoom a little bit better? Can we use calendars and Microsoft Word a little bit better? Can we put Word Perfect to the side and kind of go somewhere else? So, optimize first. Let's worry about the shiny objects a little bit later.
Yeah, there's definitely a lot of low-hanging fruit that can be implemented to make things better that are easy to do.
Yeah,
You don't have to jump into AI agents or all kinds of the crazy new stuff.
right.
And I want to get into that new stuff a little bit later, but first off, I'd like to learn a little bit more about your journey. You were a prosecutor, right?
It was. Yep.
Yep. And so how that came to be that you moved from that to being a judge, and you know, more importantly, for this discussion is just how technology came into that. Like, was that always something in the back of your mind that you had an interest in and you worked it in? Like, how did that come together?
Well, before I was even a prosecutor, I was, worked at a big downtown law firm right out of law school doing products liability defense. So, we really used a lot of technology at the big firm, just from a case management perspective. And, that was important. And then you become a prosecutor, and I was part of the the modernizing of that case management system. And look, when you live and breathe the courtrooms and you are always there, you see a lot of inefficiencies. And to me, it always bugged me that, look, we have these simple tools. Can't we just use them to do it a little bit better? And again, what I'm going to talk about seems very simple and very, very basic, but it is very, very difficult to integrate. It is very, very difficult to change people's minds about, hey, look, I've been doing this for 30 years. We don't need this. It's very difficult just from a mind shift and a heart change. So even if you have all the money in the world, even if you have all the technology in the world, it is still a very difficult thing to do. So as a prosecutor, I just saw 100 people are showing up at 9 o'clock. How many cases can we handle at 9 o'clock? One. So why do 100 people show up at 9 o'clock and all 100 don't show? 90 or 85 show. It's a problem from a security perspective. So I said, look, the only way that I know how to change the system to make it more efficient, more effective, more accessible is to do it from the seat up above. I thought, hey, look, I got to become a judge in order to actually be able to change these things, because no one's going to listen to, a line item DA. No one's going to listen to, a civil practitioner that's walking through the court. You need to be a leader of the judiciary, a leader of the justice system. So I quit my job, took out a major medical, cashed out a 401k, and I ran for judge. And thankfully, I was successful in 2013. And that's kind of the start of the journey that we can talk about going forward.
That's awesome. So it was really about making a change from the inside, and that was the best position to do it, especially with the court system.
Yep, absolutely.
Cool. So when you've been working on it from the inside, I remember in one of our conversations, you mentioned that, like you just said right now, that people showing up at 9 o'clock, is it called a red book?
Yep.
Right?
It's the red book.
Yeah. And
Yeah,
the red book is like an actual physical thing that is like an appointment book that you open up and the clerk puts down who's appearing when.
Yep. Yep.
And the reason why I'm mentioning this is because we can get abstract, like you mentioned, but let's talk about like a real tangible thing. And so there's this book and the clerk had it, and like something would happen, like if the clerk was sick or if misplaced it or something, what would happen?
Well, I always start with the big red book is everything wrong with the justice system, right? Okay. So if you're a civil practitioner and you have a motion to compel or a motion for summary, any motion that you want, what do? You have to pick up the phone, call the clerk's office and say, hey, when is Judge Schlegel available for this type of hearing? So you might get a live person on the end of the line, but minute clerks are very busy. They're running around, depending upon the type of system they're in, they might still doing wire baskets and running paper back and forth between multiple different floors. But let's assume that you don't get them on the phone. Well, then you have to leave a message. Then the clerk may or may not call you back in a day or two. And then we go through this. I just need a date from the court. I just need a date from the court. And let's assume that you finally get that date. You write it on your rule to show cause and you send that in and you finally get your hearing. did anybody check with opposing counsel to see if that conflicts with their schedule? So what happens? We file a motion to continue. We're hundreds of dollars of in. And we're 30 days behind. So one of the things I said was, listen, I don't even know what's coming up because that big red book has chicken scratch in it, and it's not put into the formal system until we know this is the day, this is what's going to happen. So, half the time I was walking to the same minute clerk going, what do I have set in 2 or 3 weeks? So I took the big red book and I took it away and said, look, we have these things called online calendars today. How about I put my calendar online and say, look, I can handle 9 pretrials at 9. I can handle 25 pretrials at 9. I can handle 10 motions at 10, and just provide that information to the lawyers and litigants and say, pick your own date, call opposing counsel, make sure it works for you, write it on your rule to show cause, dump it on your Outlook calendar, and I'll send you a text and email reminder to make sure that you show up with a Zoom link so that you can attend virtually for the right type of hearing. I didn't allow Zoom hearings for everything, just pretrials. Hey, how you doing? Where are we on discovery? Let's move it along. You don't need to spend 2 hours plus parking on that. It was ridiculous. So I put that online, and I know my calendar a year in advance. So I put it up there, and if I needed to cancel court because wasn't going to be there, I would just go and remove it from the calendar. I wasn't ever giving up any control of my calendar. I was actually taking back control from that big red book.
Yeah, and I know all of us, like listeners, people that are watching this, everyone has had the experience of an email chain where you're trying to set up an appointment, and you go back and forth and back and forth, and there's all different kinds of things that come up. I can only imagine doing that within the context of a court, and you're having to file like pleadings about getting dates changed. It's too much.
Yeah, and there are other great benefits. Again, like you don't have to send a runner to get a date. That saves you time and money. And my phone pretty much stopped ringing so that my minute clerk could actually spend time setting things and getting the paperwork through the system, because we weren't busy constantly. When's the judge available? What is the Zoom link? It's in the email. Check the email. You're good. Check his website. It's already embedded on the website so that you can find all this information necessary and make it readily available. And it also helped cut down on the hearings in court, because when you, Tom, would get a email from the court 3 days before your motion to compel hearing on some ridiculous discovery dispute that, judges love discovery disputes. We're like, you know what? Today I want to hear from Tom and his opponent why they can't figure this out. And you would pick up the phone and call your opposing counsel and say, you know what? Do we really need to see Judge Schlegel on this motion to compel? And half the time the answer was no. And you would send a letter in saying, we've resolved it. We don't need to come to court. So it actually made us much more efficient in that way, just because you got an email that triggered you, the lawyer, to pick up the file, to get ready and go, we're good. We don't need the court today.
So one thing I want to talk about is, and you had mentioned it, is that it's really the harder part is the cultural change, not so much the technological change. So like when we talk about something like this concrete, like the red book, I take it for that you were the one that made the decision. So did you have to get buy-in from stakeholders on that, or you're just able to make that decision?
No, that's again it's my docket. I'm running it. I set the calendar. So it was, I certainly had people bad mouthing me that I had made that decision, but I didn't need permission.
Well, what about, I'm sure when you did it, other judges were thinking like, is that working? Is it not working? Probably asked you about it. What do you recommend to me? Do you think I should implement this? What were the kind of themes that you were getting from that? What were like the sticking, the blocks for other judges to take that on? And did that eventually catch fire?
Yeah. And before I go on to the judges, let's start with the lawyers.
Yeah.
It took at least 90 days, to 6 months for the lawyers to even understand the concept. It's like, wait, what do you mean? What do you mean I can go online and check your calendar? Because when you think about it, you're not getting the same lawyer for this, each week. So it takes time for all the lawyers to understand and appreciate we can check the calendar online and to actually believe it. Even when you go and pick it, you're like, is that really what they want or what they are allowing? And so, it takes a good 6 months just from the lawyer's perspective to understand how to use it, when to use it. Is this real? Can I rely upon that date? Because again, you're not just changing the judge's thought process, you're changing the justice system's thought process. And that's we haven't even talked about the criminal side of it, which we'll talk about after we finish the civil side of this discussion. But from a judge's perspective, it's the same thing. Some judges like it, some judges don't. Some don't find it, again, I make it seem easy, but there's still a lot of decision points that you have to make that aren't that easy. What's the language going to say in the text? What's the language going to say in the email? What happens when I get sick or I go on vacation or I go to a conference? Who's going to handle deleting and adding hearings? How many can I handle at 9? How many can I handle at 10? How do I integrate Zoom through an API with Squarespace, or what are all these different acuity scheduling or count? How do I do all of these things? So it's not as easy as it might sound, unless you have the basic technical experience to do it. And judges aren't technologists, and technologists are not judges. So these are, this is the real difficulty. Who's going to pay for it? How are you going to get reimbursed if you have to pay for it? That's, oh, by the way, I've got a murder trial that I'm in right now, and I've got a rape trial the next day. Oh, and then I've got a big multi-million-dollar 3-week litigation. There's no time to pause and do these things. I've got to get ready for my hearings. So it's not that easy, even though it seems, when you and I talk about it, because you and I, know how to do this stuff. It seems easy, but it's certainly not.
Yeah, so you definitely have, like, in a court-wide system, you have all the judges, then you have all the lawyers, and in addition to that, there's not only the political changing of minds and the cultural change, but also the educational element of getting everybody in the loop about what this change is, what it means, how to do it, to make it a smooth transition. And that sounds like a lot of moving parts. And I could see why it would take so long.
And that's not even talking about the fact that it's not integrated into the clerk of court's case management system. It's a layer on top of, so it's not even the online calendar is not even the real record. It's simply the red book. It's the layer on top of the real record, and so that's hard to get people to contemplate as well. What do you mean? I scheduled on the calendar online. I should have a hearing today. No. Did you read the instructions that say you have to file a rule, that's an order, and that it's not a date for the court until it's signed by the judge? So just that content, those types of thought processes.
So all of this change has just been, multiplying itself across all the states, all the individual, levels of courts within each state. And then we have our local court rules that have been promulgated by different judges. So it's been an amazing change. And I know that, like, in California, where I'm licensed, everyone can appear by Zoom ever since the pandemic started. And before then, there's telephonic appearances. But still, that's just like one minute little tiny piece of all this.
Yeah, and and we can show how judges are different. I hate telephonic conferences. I can't see your face. I can't see you talk. You talk over each other. I don't know what's going on. So I never permitted it. I said, you can come by Zoom, but you're not coming by phone, because I can't deal with the talking over one another. And that just shows you why this is even more difficult, because some judges think, I'd rather you be in person because I can talk to you. I can help you through it. I can get you to talk to your clients. I can get you to talk to opposing counsel. I think there's more value in the face-to-face as opposed to the virtual. And this is your, push and pull that you just have to work through. It takes time.
Now, you mentioned criminal was different, or there were additional changes for the criminal court.
Yep.
How's that?
So I used the same concept in criminal, but as you know, civil justice system and criminal justice system are absolutely different workflows. And what I always try and tell everybody when dealing with new technologies is, look, you are the expert in the workflow. That is the most important thing. You need to really understand your workflow. Once you've understood your workflow, then you need to go work out your partnerships with your justice partners and any of the stakeholders involved, and kind of talk it through with them and get some buy-in from some folks and figure out how it works. Then you can pick your tech stack. The tech really is, and I don't want to say the easy part, but the tech is the easy part because you guys, you smart guys, have already developed it. You've already done the hard part. You're developing it. I'm not an expert in tech. You are, but you've shown me here are different products that I can use. So once you've done all that, now let's fast forward to criminal. I'm still, by the way, Tom, on the same $150 a year that I spent on the civil online calendar, same $150 on the criminal side. So how do we do it on the criminal side? Well, on the criminal side, we didn't allow the criminal defendants to pick their dates online. So we didn't use the calendar and make it a public facing calendar. We actually used it from an internal perspective. So let's assume that you had a case with me. I talked about 100 at 9 o'clock. Never made sense to me. So I stopped that. I said, look, I can handle 50 cases at 9, 50 cases at 10, 50 at 11, or 30, 30, 30. It doesn't matter. So you would come in on a possession of cocaine case, and I'd say, hey, Tom, you are hereby ordered to appear in this courtroom on this date. What time would you like to come? I don't care. 9 o'clock, 10 o'clock, 11 o'clock. You tell me. And then that way, I can give people an opportunity to pick a time because, look, you might have to take public transportation. You might have to drop your kids off at school. You might have to go to a doctor's appointment really early and get to me by 11. I don't care. I'm going to be on this bench until 100 cases are resolved. So you tell me what time you want to come. And when you would tell me that time, we would then input your email, your phone number, and the date and schedule a hearing for you. And that would send you text and email reminders so that we could cut down on the failures to appear. Because look, if I set 100 at 9, 85 people are going to show, 15 are not coming. 10 of them surely just forgot, or they threw that piece of paper away and they just don't remember. 5, they're running and we're coming for you. Don't pick your head back up. We got a warrant and we're going to find you at some point. But why are we issuing warrants for attachments of arrest if somebody truly just forgot? We're really just trying to get the case through and get your matter resolved. And so by sending text and email reminders with the same system, we can cut down on the failures to appear. We could also send you information about the case, like, hey, make sure you talk to your lawyer before. If you don't remember who your lawyer was, here are the phone numbers of the public defenders assigned to this division because most of them had a public defender. Here are their phone numbers. Make sure that you talk to them before you come. And that way they hopefully would be a little bit more prepared. And look, some cases we let them come virtually, even after the pandemic. Hey, how you doing? No big deal. We don't need you to come in just for and your discovery has been provided from the state to the defense. You don't need to come for that. Show up virtually, and we're going to go ahead and order you to appear at the next date during that time.
I mean, one of the things you mentioned, text reminders, is so simple. I know that I love when my dentist sends me the text reminders because I hate missing his appointments.
Yep.
But that's just me feeling bad about missing his appointment. It's not like I'm going to have a warrant out for my arrest if I miss his appointment.
Yeah. And I'm sure you've read my article about how the courts can learn a lot from dentists. I don't know what it is in dental school, but they must teach you, look, just text them every single day and you're going to get them there. And if you don't get your text, they're going to call you. And if they don't call you, they're going to come knock on your door. They teach you how to get people in to your dental appointment. So look, we're just doing the same thing. It's things that we do on a daily basis in our normal lives that I'm simply repurposing for the justice system.
Repurposing for the justice system, but you've also had a focus on budget.
Yep.
And one of the things that you mentioned, I think it's even on your LinkedIn, is like that for a budget of $1,000 or less, courts can take measures to modernize what they're doing.
Yeah.
So just for any jurists that might be watching, like what are some cost-effective ways that you would recommend to them that they can stretch a budget of $1,000 or less?
Yeah, I would say, I can change any jurisdiction in the entire country for under $1,000 a year. I would have a website, I would have an online calendar embedded, and I would have a form builder that I could use. Obviously the website is your digital steps to the courthouse. And if you look at any court around the country, many of them don't even have their individual websites. There might be, you're part of the general government page and you might be able to find, Judge Tom Martin, here's his phone number. But that's about it. a lot of times it's just very difficult to find what's the fax number, what's the address, where do I need to go, who are the law clerks, who are the minute clerks, all these different things should be readily available. And so by building a simple website, every website should look and feel the same for every court around your state. But every judge page can be unique. Every judge page can be a little bit different. I never put my email or my staff's email online because I don't want people emailing whatever they want to say because of ex parte, and lawyers have a struggle when you're emailing the courtesy copy. They struggle not putting, oh, when I talked to Tom and he said, no, we don't do that around here. So I never put my email, but some judges are fine with it. And that's where you can have the individual. Some of us have different jury instructions or different service, different, like you said, local rules. And, my court starts at 9, make sure you're here for 8:45. I allow this, I don't allow that. That's where your individuality can come on the judge's page. But a website can really enable you, the lawyer or the litigant, to access the court in ways that you can't otherwise. I mean, we go to a courthouse and have to pull all these pieces of paper. Whatever you have in those like wheel arounds around your court, put them online. It doesn't even have to be sexy. Just make it a static PDF and just dump it there. If you want to get it, if you want to advance a little bit, let's get some guided forms out there. Let's get some fillable PDFs. And, then you're going to get, woo, for you tech guys, you get fired up for that. But it doesn't have to be anything. We can start small and build and layer and build and layer. Fail, iterate, fail, iterate, fail, iterate. And we just keep moving it, so that in 3 to 5 years, you're going to have something that you're proud of and that you love.
So along those lines, what are some like key factors to keep in mind when you're looking at technology where you want to ensure that it increases access to justice versus creating more friction? Like, what are some things to keep in mind to make sure that it works for people?
Yeah. Again, think through it. How would you approach it? What do you do on a daily basis? What are the complaints that you hear? What are the things that you have? And it's going to be different in different jurisdictions, and it's going to be different depending upon the type of case we're dealing with. It, obviously protective orders might be handled in one way. A name change might be handled in another way. So maybe for certain things, you want video, you want audio, you want, these nice laid out processes for them, whereas something else you don't. So I go back to what I said originally, and that is really understand your workflow and then start picking a particular workflow to start with. Again, pick something as simple as calendaring. Think through that, work through it, embed an online calendar for just civil, just a particular type of hearing that requires a Zoom link. And then once you figure that out, then you can layer from there. All right, I don't want a hearing when it comes witnesses because I don't know how to handle Zoom, but hopefully in 3 months, 6 months, I'll be able to handle simple witness testimony online because I've now learned how to use breakout rooms and I've learned how to use, all these different tools within the tool. So I always try and tell everybody, just pick one. Pick courtesy copies. Let's start there. We talked about the email and courtesy copies. One of the benefits of the form builders is that it allows you to drag and drop courtesy copies. So I use the form builder to build a drag and drop feature for courtesy copies on my personal webpage when I was at the trial court, so that when you filed your motion and if the court requires a courtesy copy, you would typically mail 75 pages that went straight into the trash can when I saw it because the hearing was already over by the time it got to me, right? Or it got to me and I was reading it digitally already. Stop wasting your money. Stop wasting your time. Don't fax it to me because most fax machines, have struggled. They struggle after 20 pages, So just drag and drop the PDF. And once you did that, it hit my OneDrive and I was rocking and rolling with your courtesy copy and I could push it wherever I wanted to. That was embedded on my webpage using a form builder. That's just one simple workflow, courtesy copies, that I thought through. And I thought, how can tech make it easier and better? And that's things we do every day on our phones in our real lives.
And it's a great strategy. It's one that borrows a little bit from tech in terms of like the idea of landing with something small and then expanding.
Yep.
Get to know that small use case really, really well, and then see how you can carry that into other things. So that I think that's a great advice for everyone out there. Um, I do, I do want to get into the whole AI stuff
Yeah, sure.
because I think not so much in terms of like how it can be sexy to use it in the courts, but more so how like it's going to impact the courts, how it's going to impact us as people, because the rules of evidence seem almost they still apply, but in some ways they feel like they're thrown out the window because we have authentication and all these questions about how that's going to change with AI. And so let me start kind of broad. I just want to ask you, um, how do you think AI is going to affect future developments in the courts?
I mean, how much time do you have, Tom? Look, let's just go all the way back to, again, everybody's talking about AI, and when they say that, obviously they mean generative AI, and they don't know that they mean generative AI when they're talking about AI. So let's just talk about GoFi for 2 seconds, right? Good old-fashioned AI. How can that help us? Well, I just told you that I could handle 25 pretrials at 9 and 10 motions at 10. Why am I not layering AI on top of case management systems that say you really can't, judge? You can handle 21 pretrials at 9 and you can handle 7 motions at 10. And if you want, you can handle another 3 at 11. But if we start giving it the appropriate layer on top of our case management systems, it can do everything I just told you without me having to do it. I don't have to go in there and go, all right, let me schedule 25 on Monday. I can just tell AI what's the most efficient based upon the years past of information that you just saw. Can you go create my calendar for me, create the language that I need, and send it out for me? Those are simple things that people like you can do in your sleep, but you don't know my workflow, so you don't know maybe I should be thinking that way. So I think the most impactful that we're going to have is just those type of simple layers on top of our case management systems now that we're, starting to see how this goes. And so if you take that and you start iterating from that, all right, we talked about an online calendar, right? So if you then get that email that you need to come to court, it sent you the Zoom link, whatever that is. When you come to court and we're having these virtual hearings, why do we not have transcription running at the time of the hearing? And why, when I hang up and tell everybody bye on Zoom, it's my favorite part about Zoom court is everybody still has to say bye. We don't do that in the real world, but everybody says bye after the hearing. When you and your opposing counsel walk out the door and I said, hey, Tom, counsel, please generate an order and have it to me within 5 business days of what happened, half the time y'all walk out and go, what did the judge say? I have no idea. And then you all send competing orders out. Why are we not sending you a transcript immediately after the hearing? It doesn't have to be official. It can be watermarked. You still have to order an official transcript if you need one. But then you and your opposing counsel, and why are we not having it generate an order based upon what I just said that you and opposing counsel can look at together and go, yes, that is right. Yes, that's what the judge said. Yes, that's okay. And you submit it. Why are we still wasting all this time fighting over what the judge said and fighting over these competing orders when I could do it with the push of a button if I just layered it from the beginning? And then you can go back to your clients and say, here's what the judge said. If you want to take them up, that's fine. We're going to have to order this transcript. We're going to have to do it all. But here's what he said, and I think he's right. Or I think he's wrong, and we should. So let's go ahead and order the official transcript. Those are simple things that we can do today if we knew how to layer GoFi, right? There's not really much to that one.
Yeah, I totally agree. That would be it would be fairly simple to train it on past data and see like how generally like what time frame it takes you to go through different types of motions or hearings and then schedule accordingly. And that idea about putting a draft proposed order together sounds like an amazing time savings there.
Yeah, and it's based on the transcript that we just sent you because I already have your email from when you scheduled the appointment. the appointment, the hearing.
Right. So, okay, I would be remiss if I didn't ask you about what your policy is on lawyers using AI to draft motions, because we got the Schwartz case, the infamous
Yeah.
Schwartz, and
Yeah.
all the other cases that have come down since then, which are kind of shocking that they're still coming
Right.
almost every month. But what is your take on, you know, do you have a written policy that says don't use AI or disclose use of AI? And once you tell us what your position is, what do you think about, like, just generally with the court systems, if they should be doing that?
Yep. So let's start with I've written an open letter to every judge in the country that says education over regulation. I don't think that we need orders saying you may not use AI. First of all, if you put out an order that says you may not use AI, you're not making a distinction between Gen AI and AI. So what you're telling lawyers is do not turn on your computer because you may not file anything with the help of any digital assistant. You must use pen and paper. If you say you cannot use Gen AI, what does that mean? I can't use Westlaw now? And if I use Westlaw or Lexis or Fastcase or VLEX or any of these things, that's using Gen AI to help with the research and help kind of go back and forth with you. So, can you not use it? Do you mean Grammarly? Can I use Grammarly to clean up this sentence or not sentence? So, I guess the point is a lot of these orders are imprecise simply because we're all still learning. We're all still kind of figuring out what AI is, what Gen AI is, what can it do, what can it do. And so I would say our rules of professionalism, our rules of conduct, everything that we deal with on a daily basis already covers everything that we need. You have rules of competence, you have all these different things. So do not file something if you have not checked the citations. Do not file something if you do not believe it's correct, because the Rule 11 or its equivalent, we can sanction you, as Mr. Schwartz was done, and as many lawyers continue to do, when it hallucinates, because we already have that authority. I always like to ask everybody and remind everybody we've been here many, many times. Remember when the lawyer showed up as a cat during the pandemic? I was very upset that didn't happen to me, Tom. I told Roy, the judge Judge Ferguson, that it happened to. Why didn't it happen to me? Why didn't it happen to him? Did we all of a sudden rush out and say, no more Zoom? You cannot use Zoom ever again. No, we said, learn how to use Zoom. There's this thing called filters. Turn them on, turn them off. Make sure your camera angles are right. Make sure your bandwidth is good. Make sure the lighting is right. Make sure that we can hear you, and make sure you use the mute button, which people still don't know how to use, which is amazing. But we didn't shut down Zoom. We said education over regulation. And we can do the same thing today with Gen AI. So I encourage lawyers to use it, but use it only after you know how to use it and you understand the privacy settings and the confidentiality issues, because you not only have a duty of candor to the court, you have a duty to your clients as well when we're talking about the confidentiality of their information. So if you don't know how to use it and you're using a free version, stop it now. Do not use freemium anything. And remember, it's not a legal tool. It can be used by a lawyer who knows how to use it, but it is not designed to be a legal tech tool.
I completely agree with that position. That's what I've, put out there too, is that I think that, Rule 11 and other rules that we have in place that say you as a lawyer are responsible for what you submit to the court. So be careful about that. And in a way, it's kind of shocking that it's revealed in a way that lawyers haven't been doing that, even in the analog way of reviewing their own work product before they submit it. So that's a little scary.
Yep.
But also, like you're saying, don't throw the baby out with the bathwater. Zoom is still good, AI is still good. You just need to know how to use it.
Yeah.
Those are all great words of wisdom, and I don't want to leave out some of the scary things that are happening with evidence. I'd love to hear your opinion about that, because now, like, I think Microsoft just released this model where you give it a few minutes of audio of just like a picture, like one photograph.
Yeah.
And thankfully, thank God, it's not publicly available yet.
Right.
But when it is, and then, OpenAI already had their Sora and all that.
Right.
how is this going to impact the courts? How are you guys going to deal with that? Like when somebody submits a video, which used to be the gold standard, how are you going to tell it apart?
Yeah, this is a challenge. This is what we talk about all of the time. Look, I'm sure you've seen my deepfake videos. You can see all of them at judgeschlegel.com. I've deepfaked myself. I've cloned myself. It's a real problem. The video, I think, and we're talking about the consumer level products that are now, unfortunately, everybody's getting their hands on them. You said you can't do it Microsoft's, but there are other tools that you can do similar things, may not as good as Microsoft's, but you can do similar things with just the one photograph of you. So, with the video, I think there's still things that you can tell when just the naked eye looking at it. If you're paying attention, I think you can still tell when video is deep faked. And I'm talking about the people who put low effort in and just use the consumer level. Now, there's guys like you that can create a deep fake video that I can never tell the difference without hiring an expert. But I don't think the video is there yet, but it will be here in 3 to 6 months, 9 months, a year. So yes, we need to start thinking about it. What scares me the most are audio cloned voices. If you leave me a voicemail, I can clone your voice in under a minute and have you say anything and everything I want you to say. So how does that impact the courts? Most frighteningly are protective orders in domestic cases, in my opinion. Every day, trial courts around the country are tasked with protecting folks from violence. And if you have somebody come in and say, this is my voicemail of my boyfriend threatening to kill me, I, a bad actor, know your name, know where you work. I know all of our animals. I know all of our kids. I know all of our addresses. I know everything personal about us. I can feed a script in ChatGPT or any other LLM, create a nasty script, dump it in a audio voice clone your voice software and present that to a court, and that judge is going to sign every single time, and you have lost the kids, you have lost the house, you have lost your firearms, you have lost everything. But hey, you can have a hearing in 10 days after the TRO is about to expire, and you're going to walk in there and you're going to say, Judge, that's not me. And they're going to play that tape and you're going to go, yeah, okay, it's not you. Great. Most people are not going to have experts. You're not going to have who is an expert, by the way, Tom? I'm still trying to find out who are the experts, and I'm sure there are them, but what are they going to charge? Are we going to live in Daubert motion and eliminate hearings all day, every day for all this stuff? And while all this is happening, nobody has any money for this. Most of these protective orders and most civil cases have at least one side that is self-represented. So you could say it all you want, but if it's convincing enough today, what is it going to look like in 6 months when the video is good enough, when the audio is matching the video, when we have all the different photographic evidence? And as you said, we could just keep doing this: sexual harassment cases, sexual discrimination cases, all these different things. We're going to have to deal with it. And I don't have an answer for you other than, you've got big tech saying we're going to watermark our stuff, but as you know, you can fake that too. So you're going to have to go to the device level. C2PA, I think, is the standard that people are talking about doing the authentication on the device level. I mean, look, I don't have answers. I just read about this stuff, and right, when you take a photo with these new Android phones, you can like erase things that weren't that are there, or add things that weren't there, and move things around. Who's going to come in and tell me that photo taken on that device was manipulated or not? Nobody has time or money for that.
And that part about the money, I think, it's a huge problem. But like, I completely get that, where you have people fighting over custody and nobody has enough money to support themselves, let alone hire some expert to prove that the audio is faked.
Yep.
It's a little crazy. And also, like, even if you implement the solution where there's some kind of tagging or there's some kind of verification at an electronic level that this is in fact, real.
Yep.
There still may be people like they have an analog way of taping it, and that's all they have. Are we going to now say that those by default are like not trustworthy and you can't submit that evidence?
Yeah. Look, how do you authenticate a voice a message of somebody. That's my boyfriend. That's his voice. That he left that on my phone. All right, we're good.
Right. Brave new world, huh?
Yeah. There are great positive use cases for this deepfake technology that I've said before. Think about it from an access to justice perspective. We have all these videos that we, spend $30,000 editing, getting it ready for what do I expect as a juror? How do I fill out this protective order? What do I do if I've been threatened? We have all these different forms and all these different things that we have all over the courthouse, but no one knows where it is or what it looks like and if the information is updated. I mean, we can take the same technology to scrape our old handbooks, create a script that gives people the information, not unauthorized practice of law, simply providing people with information, dump it into my deepfake video creator, and have an actor or an actress in any clothing, any setting, any language that I want, in multiple languages, create these audio and video clips for the public and embed them on our websites. And we talked about text and email reminders, and link those videos to text and email reminders. So if you're a criminal defendant and you don't know what to expect, hey, what to expect? You're going to have to go back to court. Make sure you talk to your lawyer, whatever I want to do. And we haven't even talked about probation and parole that you and I have discussed on many occasions.
Right now, I'd like to turn a little bit from, the AI discussion to more about giving advice to others, about how to approach their career and what they do. You've held various different positions. You're rising through the judicial ranks. And if there's somebody out there who has a passion for law, for the court system and technology, what would you recommend to them if they're starting today as a way of putting those things together?
Start today. Look, and it's going to change. It's going to change over the years. And so, first, I believe that we're all, uniquely called to a certain area. We all have unique skill sets, and we all have unique gifts and opportunities and abilities. So, it's different for each and every one of us. Before I quit my job and ran for judge, I made sure my wife was on board, because I was, married at the time and still, married for, 25 years, and we've been high school sweethearts. So I don't do anything without talking to my wife first about what we want to do for, and just go towards, and not be afraid of what's next, but also have wisdom. Probably wasn't the smartest thing to quit my job and cash out a major medical. But, I felt called to do it, and my wife was on board, and, I took a chance. But that doesn't mean you take a chance all the time, every time. It's very complex and complicated, this thing called life. So what I would say is, make sure that you think about it, develop a plan, and, execute, and be ready to fail and be okay with, failing. And all right, I failed, big deal. Now what? Let's go. Let's keep going.
Well, the failure thing, I mean, it's really, it's how we learn.
Yeah.
We learn from trying things and seeing if it works or not, and then we keep trying until it does work.
Right.
One of the things you mentioned, about, talking to your wife about the career choices and all that, that ties in for me about one more thing I'd like to ask you about, is just with all that you have going on. Like, you have, your hat on of being a judge, a technologist, family life. Like, how do you keep all of that balance? Is there such a thing as work-life balance, or is it really about choosing something that you just love doing that fits in with your personal life? Like, what are your thoughts about that whole discussion?
Yeah, that's that thing. I never work a day in my life. I love what I do. I love every aspect of what I do. That work-life balance is, individual. And I couldn't possibly answer this is the way, because I don't think that that's a question to be answered. And there's different stages of your life and different times where you're, working a little bit harder than you should. But then later in life, you're like, I'm good. I've done that. I don't need it. So, and I think that's different from every person's perspective.
Well, the one I like to close on is what makes it worthwhile for you? Like, when you're doing all of this at the end of the day, what makes it worthwhile.
Yeah, look, I think it's a calling of my life to give back and to help people uh, through whatever that is that they're going through. So to me, it's a personal calling that I feel that, and I've been given this unique opportunity to hopefully have a positive impact on the justice system. And your backyard's my backyard. So I never do anything thinking it's just for this jurisdiction or this. I always think of it as we're doing this to make the justice system more efficient, effective, and accessible for everybody. And if I can show you how to run the 4-minute mile, I'd make it a little bit easier for you.
Any final thoughts you'd like to share?
No, just appreciate you having me here, and appreciate all the work that you've helped us with over the years, and trying to meet that goal.
Well, Scott, it's always, excuse me, Judge Schlegel, it's always been
Scott's fine.
It's always been my pleasure, and it's been a pleasure to have you on the show today. For people that want to keep in touch with you, how would they do that?
JudgeSchlegel.com has everything that I just said up there. You can look through it, have some fun reading the blogs and the deepfake videos, and then Twitter and LinkedIn.
Awesome. So everyone watching or listening, thank you so much for following the LawDroid podcast today with Judge Scott Schlegel. It's been amazing, and I hope to see you next time. See you then.
Thanks for having me.
Thank you so much for watching the latest episode of the LawDroid Manifesto podcast. To keep in the loop about upcoming episodes, please subscribe to LawDroid Manifesto and you'll get notified. Thanks for watching. See you next time.